Yo, what's up, man? We locked in. We locked in. Got the dope coffee here. Yo, if you a lawyer, a law firm, real estate agent, real estate broker, mortgage banker, mortgage broker, insurance person, tax business, accountant, or you any kind of business and you want to advertise on my channel, right? Look at my steam right there. Look at my steam on my coffee. Look at my steam. Crazy. Email me, thepodcastwithsoul@gmail.com. Amendment 826 to the United States Sentencing Guidelines revises 1B1.3 relevant conduct. Send this video to Mark Agnifilo. Send this video to Tenny Garagos. Send this video to Jason Driscoll, Xavier Donaldson, Nicole Westmoreland, Brian Steele, Anna Esteveo, Alexandra Shapiro, Brian Steele. Send it Jonathan Box. Send this to all Puffy's attorneys. Amendment 826 to the U.S. Sentencing Guidelines Manual revises Section 1B1.3 relevant conduct to exclude acquitted conduct from being used to increase a defendant's sentence under the federal sentencing guidelines, according to the United States Sentencing Commission. This means that conduct for which a defendant was acquitted in a federal court cannot be considered relevant conduct when determining the guideline range, unless that conduct also establishes the instant offense of conviction, according to the U.S. Sentencing Commission. The amendment took effect on November 1st, 2024. United States Sentencing Guideline defines relevant conduct, which includes all acts and omissions of the defendant and acts and omissions of others that were in furtherance of a jointly undertaken criminal activity or reasonably foreseeable in connection with that criminal activity. This amendment specifically addresses the issue of acquitted conduct sentencing, where judges previously considered conduct underlying charges for which a defendant was acquitted when determining their sentence. Exclusion of acquitted conduct. This amendment prohibits the use of acquitted conduct to increase a defendant's sentence under the guidelines, promoting fairness and public perception of justice, according to the United States Sentencing Commission. There is one exception. This amendment, my man on that bike, it's pouring rain out here. The amendment carves out an exception. Acquitted conduct can still be considered if it establishes the instant offense of conviction. I don't know what that means. It's important to note that this amendment only applies to federal acquittals. Federal judges can still consider acquitted conduct from state and tribal courts, and under 18 U.S.C. 3661, they can generally consider a wide range of information when determining the appropriate sentence. Pull this down from the United States Sentencing Commission. This amendment revises 1B13, relevant conduct, factors to determining the guideline range, to exclude acquitted conduct from the scope of relevant conduct used in calculating a sentence range under the federal guidelines. Acquitted conduct is unique, and this amendment does not comment on the use of uncharged, dismissed, or other relevant conduct as defined in 1B1.3 for purposes of calculating the guideline range. The use of acquitted conduct to increase a defendant's sentence has been a persistent concern for many within the criminal justice system and the subject of robust debate over the past several years. A number of jurists, including current and past Supreme Court justices, have urged reconsideration of acquitted conduct. Sotomayor, respecting denial of certiorari. In denying certiorari last year in McClinton, multiple justices suggested that it would be appropriate for the commission to resolve the question of how acquitted conduct is considered under the guidelines. First, the amendment revises 1B13 by adding a new subsection which provides that relevant conduct does not include conduct for which the defendant was criminally charged and acquitted in federal court, unless such conduct also establishes in whole or in part the instant offense of conviction. They argue that consideration of acquitted conduct at sentencing contributes to the erosion of the jury trial right and enlarges their already formidable power of the government, reasoning that defendants who choose to put government to its proof face all the risks of conviction with no practical upside to acquittal unless they are absolved of all charges. For these reasons, acquittals have long been accorded special weight, distinguishing them from conduct that was never charged or passed upon by a jury. Let me read this. Second, the Amendment 826, adds a new application which instructs that in cases in which certain conduct underlies both an acquitted charge and an instant offense of conviction, the court is in the best position to determine whether such overlapping conduct establishes in whole or in part the instant offense of conviction and therefore qualifies as relevant conduct. The amendment thus clarifies that while acquitted conduct cannot be considered in determining the guideline range, any conduct that establishes in whole or in part the instant offense of conviction is properly considered even as a relevant conduct, and even if that same conduct also underlies a charge of which the defendant has been acquitted. During the amendment cycle, commenters raised questions about how a court would be able to parse out acquitted conduct in a variety of specific scenarios, including those involving linked or related charges or overlapping conduct. Example, conspiracy counts in conjunction with substantive counts of obstruction of justice counts in conjunction with substantive civil rights counts. Commission data demonstrate that cases involving acquitted conduct will be rare. So, look this up on your own. Amendment 826 of the Federal Sentencing Guidelines says that Puffy was acquitted of RICO and all of the predicate acts under RICO that they charged him with: bribery, arson, weapons, possession with intent to distribute, sex trafficking, coercion, forced labor. None of that can be used to enhance his sentencing guideline range. So whatever his base offense level is, it looks like that's what it's going to be. Base offense level 14. But send this over to his attorneys. There's one exception. The amendment carves out an exception. Acquitted conduct can still be considered if it establishes the instant offense of conviction. I don't know if this applies to Puff, but good news for Puff. Good news for Puff. Good news for Puff that none of the charges he was acquitted of can be used by the senior probation officer in preparation of his PSI to calculate his sentencing guideline range. Amendment 826 under the United States Sentencing Guidelines. If you're an attorney, mortgage company, real estate broker, real estate office, insurance company, title company, lawyer, and you want to advertise on my show, email me, thepodcastwithsoul@gmail.com. Peace.